decades, there's also an increasing interest from donors and international organizations to work with, and preferably at the same time to stimulate some kind of change in customary justice systems. So when we look at land, we see that after independence in the 1960s, the dominant idea was that customary land tenure would not sustain the productivity growth that we were looking for, would not work in a modern society, and was basically discarded as good for independent Africa. And you see all this programming coming in that facilitates ITR, individual titling and registration. A little while later, a couple of decades later, there is quite a lot of proof showing that these titling programs have not brought what they want. And there's a sort of rediscovery of customary justice systems, at least to the extent that that's the reality we need to start from, and we need to think incrementally in changes from that. Similarly, in the rule of law programming, we see that in the early 1990s, law sort of comes back in, starts to play a prominent role again in development. First of all, in the first period, all of that is going into strengthening of legislation and legal institutions at the state level. So we're saying judiciary, prosecutors, police, etc. 1-2 decades into all of that, there is a clear disenchantment with what has been labeled the rule of law orthodoxy and a sort of rediscovery of customary justice systems. So there's actually two kind of responses based on that disenchantment. One is to take a more direct pro-poor approach, directly targeting people and saying, what is it? What makes that they can't access these systems? So that's where the access to justice and the legal empowerment programming comes in. And the other, as I said, was basically a rediscovery of customary justice systems with a somewhat belated recognition that actually these are the justice systems that for most is the legal system that regulates their access to natural resources, their family relations, their inheritance, etc. Now, interestingly enough, these two responses do not really meet. The customary justice programming does not focus too much on issues of access, of power, of empowerment. Almost as if development practitioners regard working with customary justice systems as automatically being bottom-up, as automatically being legal empowering. And obviously this disregards issues of access, of power differentials, of elite cooptation that we see in customary justice systems, just like we see them in state justice systems. So what I'm trying to do in this paper is look at two countries that have gone through customary justice reform that have taken very different approaches and see what those approaches mean for legal empowerment or the lack of legal empowerment for the groups that they were meant to empower. And so let me tell you a little bit about Ghana. So like many other countries in Africa and elsewhere, you see that in recent years land transactions have increasingly monetized in Ghana, which has resulted in severe contestation of rights over land. And again, as in many countries, particularly also here in South Africa, we see that this has increasingly concentrated control of economic benefits flowing from land in the hands of traditional chiefs. So in that context, the Ghanaian government started a comprehensive, heavily donor-sponsored, and I should probably say donor-induced, land administration program to enhance land administration in Ghana, which focused both on the state and the customary sector. Now, with regard to the customary sector, the land administration program sought to do was to enhance the functioning of customary land management through the creation of what they called customary land secretariats, described as efficacious land administration structures, quote, with appropriate governance structures to assure institutionalized community-level participation and accountability in the use of stool land, which is customary land, and the revenue it generates. So there were twin goals in this programming of greater certainty for ordinary land users on the one hand and gains in efficiency and fairness in the land market on the other. However, of course, that could only be met, those twin goals, if the land secretariats as an institution were designed in such a way to promote the land rights of smallholders. However, what's happening in practice is from the inception of the program, you see that the government makes the political choice to that these customary land secretariats should fall under the aegis of the chiefs instead of opting for more community-based approaches to the management of customary land. So instead of going for a clarification of the nature of the usufructuary rights of families and individuals to secure their tenure of these smallholders. What is happening is that during the conception and design of the program, there's not even any open discussion of this role of the chiefs in the administration of stoolland, and particularly of this tendency of chiefs to behave like private landlords, or of the possible checks and balances to be placed on these chiefs. Now, quite the contrary, actually, because the need to gain support of those chiefs where they want to place those customary land secretariats leads them to severe restraint in pushing for clarification of the rights of landholders. And at the start of the project, what they're actually doing is government is presenting this idea of customary land secretariats to the chiefs basically as packages of equipment and technical support to do their land administration more efficiently. And there was a provision that they could make MOUs, Memoranda of Understanding, between the government and the chiefs. And there's actually a nice memo of the government that advises against the use in those MOUs of language which might be interpreted by chiefs as imposing requirements of accountability or disclosure of revenues. So this is the backdrop, this is the context in which they start 10 pilot customary land secretariats. Now, it won't surprise you, or if it does, then I'm not doing my job well or you're sleeping. But it won't surprise you that what is actually happening is that the chiefs were able to use those land secretariats to consolidate their control. So both to speed up conversion of, for instance, agricultural land to residential land of community members, and also with regard to people who had, so in areas with migrant farmers, you see the land secretariats were seen as a way to convert secure tenure arrangement of migrants, which were created through long-established oral and sometimes written sharecropping contracts with landholding families, which are arguably equivalent to land purchases, into fixed-term leasehold subject to rent collection and eventually discretionary renewals by the CLS. And that reminds me of the story of KZN and the Ingonyama Trust that we heard yesterday. Okay, so this is the Ghana story. Now I'm going to be even shorter on the Namibia story to stick with my time. So the contrasting case is Namibia, where in the northern area there is a Ukwambi traditional authority that, with some pressure of the government, decided to try and enhance the role of women in customary justice systems. And they took action in 3 realms. One, they tried to change some of the norms that were detrimental to women, such as property grabbing. The other is they increased the number of female traditional leaders. And third, they tried to encourage participation, more active participation of women in traditional court meetings. And this actually led to quite some positive change. The new female traditional leaders were well accepted. Their administration assessed quite positively. The scene of traditional court meetings changed enormously with very active participation of women as judges, as parties, as participants or audience. And the majority of court users satisfied with the performance of the courts and saying that they felt they get equal judgment, equal chances in these courts. And one of those new norms, the one prohibiting property grabbing of the widow after the death of her husband, was very widely known, and the practice had gradually declined. So why these 2 cases? What am I trying to show? So it's very clear that in Ghana, both researchers and policymakers agree that basically the programming failed to enhance tenure security for smallholders. In Namibia, which incidentally is a country where both proponents and opponents of gender equality have this position that, or have this belief that women's rights and customary justice are eternal foes, we do find significant positive change. So how can we explain that these women in Namibia were included in customary justice systems, structures and processes, where in Ghana the participation of smallholders in customary land management was negligible, and accountability and transparency of traditional leaders not enhanced while their powers were formalized? Now, there's 2 differences that I won't go into, I'll just mention them. One is that in Namibia, the changes were initiated at the local level by the traditional authority and the chief, whereas in Ghana, they were heavily sponsored, induced by donors, And the government took a clear role in that, but didn't have the political will to actually push it through. The second is that there's a different scope of economic opportunities, which is much higher for traditional authorities in Ghana than it is in Namibia. But what I want to conclude on before Nalini starts waving her 1 minute note is what these two case studies show is that obviously if you want to deal with and you hope to bring change to customary justice systems, the approach you take matters. And that approach needs to be linked to the nature of customary justice systems. Customary law is unwritten. It doesn't have a clear lawmaker, which means the norms, the content of the norms is formed, is negotiated and renegotiated in leadership structures, but very much also in customary court procedures. So, and they're also defined vis-à-vis external structures, think particularly of the state, when these have the power to enforce or formalize or recognize land rights. So in that context, obviously it's highly relevant which people or which groups have, are given or are able to appropriate the power to define customary law. So for groups to be empowered, whether we're talking smallholders or women, they need to be included in the spaces where law is defined and negotiated. So in Namibia, you get the inclusion of women in leadership struggles and in traditional dispute settlement, which meant they became part of the very structures where customary law is formed and is negotiated. It also means that they will see in dispute settlement, they will find out, just by being there as audience, they will know the norms, they will know the rules, they will know because of that when one of their own rights has been violated. They will also know the rules of the game. What can you contest? What can you negotiate? Often decisions, particularly as to the amount of a fine, for instance, are negotiable under customary law. So they have become part of these structures where this customary law is formed and negotiated. In Ghana, in contrast, the land administration program, it triggered a formalization of customary land rights. So as such, it provided a particularly potent moment for such renegotiation of customary norms, of the content of customary law. But there was a failure to include the smallholders in this process of defining the functionality of the customary land secretariats and in the definition of which customary land rights were to be protected. So that actually led to elite capture of local land rights. So to sum up, there's these two changes we see as a response to the rule of law orthodoxy failure, bottom-up approaches, and looking at customary justice systems. And what I'm arguing in this paper is we should take them together. We have to look at the power differentials within customary justice systems. And we have to focus on what I call customary legal empowerment, which looks at participation and access to these structures. Thank you very much.